Welcome to the lecture for week 4 in the Law and Bioethics course, which will cover confidentiality, disclosure, and duties to third parties. The goals of this lecture are to review the legal and ethical basis of medical confidentiality, to review the nature of physician-patient duties, particularly as they relate to confidentiality and disclosure, to review ethical and legal obligations governing mandatory and voluntary disclosures, and then to talk briefly about how these principles and rules may compete with one another. The origins of medical confidentiality date back to at least ancient Greece and the Hippocratic Oath. I mentioned earlier in this course that the Hippocratic Oath was primarily a guild rule that contained principles like not to share the secrets of medicine with anyone other than the sons of other doctors, and not to perform surgery for fear that surgeons would start practicing medicine at a time when the two were separate professions. But the Hippocratic Oath also contains several ethics rules. One of those, as I mentioned earlier in the course, prohibits sexual relations between doctors and patients. And another protects medical confidentiality and warns doctors not to share their patient secrets with others. Confidentiality has long been expected of doctors, both through professional organizations and customs, and through state laws and regulations. But these were finally federalized in 1996 as a result of what is known as HIPAA, the Health Insurance Portability and Accountability Act. Much of the law dealt with being able to maintain and transfer your insurance from job to job, but it also contains significant provisions protecting patient confidentiality. It enforces the confidentiality of medical records, but it contains significant public policy exceptions. And finally, it's worth noting that HIPAA is a floor, which means that some states impose stricter rules. For example, under HIPAA, you can share information with anybody else in the medical community taking care of the patient. But in my state, New York, you're only allowed to share this information, except in emergencies, with other patients who work for your same healthcare institution or under the same healthcare umbrella, and not with those working at other healthcare institutions. There are many exceptions to the HIPAA privacy rule, but the two that are relevant to us today are one, that you can breach HIPAA when the information, if not shared, poses a serious threat to the health or safety of others. And secondly, when required by law. So, for example, if a court case decides that HIPAA must be breached to meet some other legal obligation, the law allows you to do so. And the Office of Civil Rights has interpreted HIPAA to include the principle that healthcare providers can share information with other providers to help treat family members unless they have specifically agreed not to do so. Of course, this leaves out in the cold patients whose relatives might benefit from the information but are not in treatment, maybe because they don't know they need to be in treatment. Baron Lerner described one such case in the New York Times in 2003. A group of healthcare professionals were evaluating potential donors for a kidney transplant recently when they received a surprise. Through routine genetic testing, the group inadvertently learned that one of the adult children was not the child of a man with a kidney failure. The transplant team struggled with the question of what to do with this information. Should the family be told? To whom did the knowledge belong? Was it ethical to use the child's kidney without telling him? It's worth noting that sharing this information can also often be devastating to families, but not sharing this information can often lead families to operate with false assumptions about their medical record. So, for example, this child may assume that he's his father's child, and therefore, when he has a child of his own and is offered genetic testing for diseases that run among Ashkenazi Jewish families, he might say, well, I know I come from a long line of Scandinavians, even though he's mistaken, and we of Viking stock don't get out diseases that affect Ashkenazi Jews, like Tay-Sachs or Canavans, and end up with a baby with one of these diseases. When a patient comes into the emergency room in psychiatry, I often ask them whether they have a family history of suicide, which helps me care for them, or what medications their relatives have responded to, which might help me choose an antidepressant. If you're mistaken about who your father is, you may be mistaken about your medical history. So some hospitals have chosen to share this information. Some hospitals have chosen not to share this information. Increasingly, hospitals are telling patients in advance that if they discover false paternity, they won't tell them. One of the special privileges that doctor-patient relationships have is that information one shares with one's doctor under many circumstances can't be used against one in court. So, for example, the physician-patient privilege in New York states that unless the patient waives the privilege, a person authorized to practice medicine, registered professional nursing, licensed professional nursing, dentistry, podiatry, or chiropractic should not be allowed to disclose any information which he acquired in attending a patient in a professional capacity and which is necessary to make him act in that capacity. And New York was actually the first state in the country to have such a law. It's important to note that in New York, the privilege is held by the patient, meaning the patient gets to decide whether or not the doctor testifies, not the doctor. And secondly, the information must be learned in the course of care and necessary for that care. So if a patient tells the doctor that they robbed a bank and broke their leg jumping out the window, that would fall under the physician-patient privilege. But if during the course of that they also mention that they broke their other leg while committing a different robbery many years before, that would not be relevant to the particular case or care, and that would not fall under the physician-patient privilege. Something isn't privileged simply because you tell it to your doctor. It has to be relevant to the care the doctor is providing. Every state has a physician-patient privilege rule. However, the federal courts do not. The federal courts have a much narrower rule that applies only to psychotherapists and patients. And this was enumerated in the very well-known case of Jaffe versus Redmond, a case in which a woman who was a police officer had shared information about a shooting with her therapist. And the question was whether or not this could be used against her in her trial. All mental health providers, if they are engaged in mental health counseling of any sort, are covered, but it only applies to mental health providers and not physicians providing care for non-mental health services. The patient generally is entitled to see information in their chart, even though they technically don't own the chart itself, and there are almost no circumstances in which the medical record can be withheld from the patient. One needs a specific therapeutic justification, which is extremely rare. So doctors should write in the chart with the assumption the patient will be able to read that chart. And increasingly, under the Patient Cures Act, the patient can see this information in real time. In my hospital, at least for psychiatric records at present, the patient has to request their full chart through medical records, which allows the hospital to see whether there might be some therapeutic justification for withholding it, but more important, allows them to offer the opportunity for the patient to have a doctor with them when they review the chart to make sure there aren't any misunderstandings. There are multiple reasons for physician-patient confidentiality. The one most well known is that patients won't share information with their providers that is necessary for medical care, especially related to sensitive subjects like sex, drugs, mental health, if they fear disclosure. On the other hand, confidentiality also invests the medical profession with authority and prestige, and it's one of the trappings in medicine that in some way makes it a mysterious profession that then may add to the trust that patients have in it. And third, the legal protection stems from the unwillingness of doctors to breach confidentiality and our desire not to jail physicians. So in the same way we don't force priests to testify to what they learn in the confessional, because the idea of jailing lots of priests for not sharing it is unappealing to the American public, the notion of jailing doctors for not being willing to breach confidentiality on the stand seems to run against public policy, and it's very likely doctors wouldn't be willing to share the information. Historically, the duty of doctors was first and foremost to their patients, and doctors had a fiduciary duty to their patients. However, this duty only arose in a contractual relationship between the provider and the patient. This differs from hospitals, which, since the 1980s, under EMTALA, a federal law, are compelled to provide care and stabilize patients when they show up at their door. In the progressive era in the early 20th century, this started to change. And although doctors had a primary duty to their patients, they also had some duty to the welfare of the public. For example, reporting communicable diseases, gunshot wounds, knife wounds, and in New York State, for reasons that remain unclear, ice pick wounds. There must have been a prominent ice pick wounding shortly before they passed the statute. And now this includes a partner notification system for diseases like syphilis and HIV. I will add that these partner notification systems were designed to be anonymous, where the provider reports to the state and the state sends a marshal to inform the partner who's been exposed. But the reality is, if you only have one source of exposure, you're going to know who shared the information. Therefore, if my grandmother were to get a phone call saying that she'd been exposed to syphilis or HIV, my grandfather would be in the doghouse for a long time. These are better thought of as duties to the state or the collective welfare, rather than duties to specific third parties, even though third parties would obviously be protected. I will mention the case of Hurley versus Edenfield once again, although I believe I discussed it last week, because it is a seminal case in the area of when a duty to an individual patient begins. It took place in Indiana in 1901. Mr. Burke's wife became violently ill during pregnancy, and he sent for the local doctor, Dr. Edenfield, who had treated the family for other illnesses in the past. There was no other doctor available in the area at the time. But Dr. Edenfield, although offered his fee in cash and being pled with by Mr. Burke, refused to provide care without offering any reason. Mrs. Burke died, and Mr. Burke sued Dr. Edenfield. The reason the case is called Hurley versus Edenfield is Hurley was Mr. Burke's agent. The courts ruled that there was no doctor-patient relationship, and therefore there was no general duty for Dr. Edenfield to help the Burkes. So with doctors specifically, you need to create such a relationship. Hospitals, on the other hand, by law, have such a relationship with them. So while doctors historically had duties to individual patients, and then in the early 20th century began having duties to the general public, the idea of duties to specific third parties is a relatively novel one. By the way, for those of you who are wondering what the slide is of, those are famous third-party candidates for president. That's John Anderson in 1980, that's Ralph Nader in 2000, George Wallace in 1968, and Abraham Lincoln in 1860. The first major case on the subject was that of Pate versus Freckle, which is a 1995 Florida case. It is mentioned in the Safer versus Pack case for this week, but is not separately assigned. And in this case, Marion New of Florida was diagnosed with medullary thyroid cancer, an inherited cancer in 1987. But her surgeon, Dr. Freckle, did not tell her that her children could be at risk. 3 years later, her adult daughter, Heidi Pate, was diagnosed with thyroid cancer. Ms. Pate sued Dr. Freckle for pain and suffering resulting from a delayed diagnosis, and she had two distinct claims: that Freckle should have warned her mother, who then could have told her, and that Freckle should have warned her directly. The Florida Supreme Court agreed with the first principle, but not the second. The court said, on the one hand, we conclude that when the prevailing standard of care creates a duty that is obviously for the benefit of certain identified third parties, and the physician knows of the existence of those third parties, and the physician's duty runs to those third parties. That means even though Ms. Pate was not Dr. Freckle's patient, in theory he could have a duty to her. And then the court said, if there is a duty to warn, to whom must the physician convey the warning? Our holding should not be read to require the physician to warn the patient's children of the disease. In most instances, the physician is prohibited from disclosing the patient's medical condition to others except with the patient's permission. In other words, the obligation of the doctor here was not to tell the daughter, but simply to tell the mother so that she could, if she chose, tell the daughter. And in fact, telling the daughter directly, the court felt, would have been a breach of confidentiality. The following year, the New Jersey courts came to a very different conclusion in the case of Safer versus Pack, which is part of the assigned reading. And in that case, Ronald Batkin was diagnosed with colon cancer in the 1950s, and he was treated by a famous surgeon, George Pack, who was actually Franklin Roosevelt's doctor. And when he died in 1964 of colon cancer, and a hereditary form of that, he left behind two young daughters. It seems that Batkin intentionally did not reveal his diagnosis to his family, and Pack chooses to honor this request. In 1990, Donna, the younger daughter, was diagnosed with metastatic colon cancer, as she did not know her inherited risk for the disease and had never been screened. She sued Dr. Pack's estate, claiming he had a duty to breach confidentiality to inform her of the risk. You should ask yourself, do you believe that Pack had such a duty? So under the standard from the previous case, Pate versus Freckle, it would have been enough for Pack to tell Mr. Batkin. But under the ruling in Safer, which is a change in the law and applies in New Jersey, but is now increasingly widely accepted, Pack also had a duty to warn the daughters independently, even if Mr. Batkin chose not to tell them. Psychiatry raises its own set of distinctive concerns relating to confidentiality. And in a moment, I will talk about the Tarasoff case and its legacy. And the question in the Tarasoff case was whether there was a duty to warn or to protect specific third parties who are threatened by patients. The duty to warn would mean actually reaching out and telling the potential victim. Now, duty to protect would mean reaching out to law enforcement or some other agency that might keep that individual from being harmed. And some states require one or the other, some states require both. It should be apparent that warning alone may not be sufficient. So, for example, if a patient is a victim of intimate partner violence, telling them that someone is coming to harm them who is a previous perpetrator may not make a difference because they may still not retreat. New York State, interestingly, has no duty to warn, which I will discuss momentarily, but there is an implicit duty to protect in cases where a third party faces intentional or imminent harm. New York State does, however, grant physicians some discretion on whether to protect and when. Long before HIPAA, the President's Commission for the Study of Ethical Problems in Medicine and Biomedical and Behavioral Research, in 1983, addressed the question of when breaches of confidentiality should occur to help third parties. And they particularly looked at the issue of risk to family members that might be shared over patients' objections. And they concluded that such information could be shared when there's a high probability that harm will occur if the information is withheld, and the disclosed information will actually be used to avert that harm. What's less clear is whether that has to be medical harm, whether it could also be lifestyle harm. So what if the harm isn't treatment for a particular disease, but rather the harm is knowing that I'm going to die at 50 and not at 70, and therefore choosing to live my life differently, rewriting my will, going to Disney World, not working as a psychiatrist, etc., etc. We discussed the case last week, but I'm sliding it in here to show you where it fits in the grander scheme of things, of psychiatrists who discover from their patients that the patients have had sexual relationships with previous providers and don't want the information shared. And here, one of the rationales for breaching confidentiality is that you're protecting the public and other potential patients from misconduct by the same psychiatrist. And that is a picture of Mike McIntyre, who is my fellow who researched this issue. As I noted last week, in New York State, and the answer varies greatly from state to state, you are a mandatory reporter of such information. So if you discover as a provider that your patient has had an affair with a previous provider, you must report the previous provider. And this generally applies to other situations where you believe that a licensed physician is guilty of misconduct and puts the public in danger in some way. Now to talk a bit about the Tarasov case, which is the defining case in the field of third-party duties. Tatiana Tarasov was a student at Berkeley who either was being stalked by or having a romantic relationship with a man named Projanit Podar. The facts of the case have been in dispute for many years, and the answer is not entirely clear. We do know is that even though Podar was defending himself on the grounds of mental illness, he later, after the case was resolved and he served his manslaughter sentence, returned to India and became a very prominent naval architect. It does not appear to have had any psychiatric consequences since then, so maybe we should be doubting his psychiatric diagnosis to begin with. But in this case, Podar goes to his psychologist at Berkeley and says that he is planning to kill this woman he may be having a relationship with or had a relationship with Ms. Tarasov. And the psychologist calls his boss, and the boss calls the police, and they take steps to protect Ms. Tarasov. But they don't take any steps to warn Ms. Tarasov. And then Podar kills Tarasov, and the family sues. And the question is to what degree they were allowed or obliged to violate confidentiality to warn Ms. Tarasov. And as the court says, the protective privilege ends where the public peril begins. You can see from this map that the Tarasov case, although it occurred in the 1970s in California, has set up a principle that has spread through the vast majority of the states. And in most states, there's either a statutory law or a court decision mandating reporting, and in a small number of states, there's discretion, and even a smaller number of states, the law is unclear. This map also gives you a sense of the trajectory of the laws, that the number of laws is expanding year by year, and that the trajectory we're going, likely the entire United States, will be covered fairly shortly. And it's worth noting that there are a lot of variations on Tarasov. So, for example, Iowa has a rule that only applies if the victim isn't already aware of the danger. Maryland, the psychiatrist is only required to warn the patient's potential victim if he has the authority to commit the patient. And at present, which is actually right before COVID when I wrote this lecture for the first time, 27 states followed Tarasov to some degree, 10 other states allowed for warning, 14 states had no rule, and Virginia actually had rejected Tarasov at that time. You should also think back to our discussion of standard of care and malpractice last week, because, for example, in New York State, there is no duty by statute to warn, and there is a very circumstantial argument that there might be some duty to protect, But it may not matter because since warning and protecting have become standard of care in practice, it may be negligent for a psychiatrist not to do so. And this is an example of how practice by physicians may set the reasonable expectation, a descriptive standard of what doctors are expected to do. In fact, the New York courts, without actually saying this directly, have in dicta or commentary in other cases assumed that warning and protecting are now part of the standard of care. I do not mention the specific New York rules for the delusion that any of you are going to become lawyers in New York State, except for those of you who already are, but just to give you a sense of the variation by states. So, for example, in New York, the duty to protect only applies to persons, not to property, which is different from Vermont. It is not retroactive. In other words, you can't breach confidentiality to report a past crime or confession. Um, it is generally a civil matter. So, except failing to protect children, it's something you can be sued for, but not something you can go to prison for. And in general, New York mental health law protects doctors for breaches of confidentiality when they're acting in good faith to protect others. Many states have also carved out specific exceptions to confidentiality as they relate to protecting against specifically dangerous actions. So, for example, in New York State, anybody who is at high risk of suicide or harm to others has to be reported under the SAFE Act so that firearms can be removed from their homes. I'm going to take a brief detour now in the lecture just to mention that sometimes the duties of providers can be commandeered so they actually become agents of the state in one way or another, which is an ethically fraught and highly debated role for providers. So, for example, 6 states now require physicians to report impaired drivers in some or all circumstances. This is not discretionary. Most states, it is a discretionary rule. I mention this because it's not clear whether or not this makes the road safer or less safe. On the one hand, reporting an impaired driver will take that driver off the road. On the other hand, you need to be aware of the systematic implications. That if you take one impaired driver off the road, but they then tell others that they trusted their doctor and their doctor betrayed their confidence, other drivers may not come forward to seek care for substance abuse or other medical or mental health needs. And this is actually what happened in the high-profile case of Keith Emmerich, who presented for treatment of an arrhythmia in Pennsylvania in 2004, confessed to drinking. His doctor reported to him he lost his license and then went on television to share what happened, with significant impact on others in the community not seeking care. You also might want to ask yourself whether you want a bright line rule that doctors have to report or a discretionary rule that they can in some circumstances. And should that change based on the nature of the activity? So maybe you don't need to report someone who drives occasionally, but do need to report someone who drives a commercial vehicle or a school bus or flies an airplane, where at some point a bright line rule might kick in. And finally, you might ask yourself, are there other ways of ensuring safe driving that don't involve physicians, such as the recent federal legislation, I believe it's in the infrastructure bill, that will require automobile companies to install devices to prevent drunk driving at some point in the future, rather than relying on physicians to intervene. You may remember the national furor a few years ago when a nurse in Utah was arrested because she refused to allow the police to draw blood on an incapacitated patient who'd been involved in an automobile accident. However, 2 states, Hawaii and Idaho, actually allow the police to force doctors to draw blood in emergency room settings. It's a criminal offense if you don't do it. And physicians can find themselves operating as agents of the state in other ways. I mentioned last week the issue of capital punishment, and this week I will mention the case of William Coleman, who was a man with complete capacity. He had no cognitive impairment, who did not want to eat. He was imprisoned and wanted to starve himself as part of a hunger protest, and the state of Connecticut ordered doctors to forcibly feed him against his will for a long-term basis. Obviously, the doctors could have quit their jobs with the prison system and refused to do this, but they were clearly acting as agents of the state, serving the state's interests rather than the patient's interests. The third case I assigned for this week, Volk versus Demerlaer, is a twist on Tarasov of recent origin. So the Tarasov case required warning and protection for a specifically identified third party. Volk versus Demerlaer, which is a Washington case, expanded that duty, at least in Washington. So in that case, Jan Demerlaer was being treated by a psychiatrist, Howard Ashby, for bipolar disorder starting in 2001. Demerlaer and his girlfriend, Rebecca Shearling, separated in 2010 after Demerlaer hit one of their children and lost his job. He presented to Dr. Ashby around that time and was described in a note as follows. Jan indicates that his life is stable. He is reconstituting gradually with his fiancée. They are taking marriage classes. He can still cycle many weeks at a time. Right now, he's in an expansive hypomanic mood, but sleep is preserved. He has a bit more energy, and my mental health status shows through as he is a bit loquacious but logical, goal-oriented, with insight and judgment intact. He states when depressed, he can get intrusive, suicidal ideation, not what he would act upon, but it bothers him. At this point, it's not a real clinical problem, but we will keep an eye on it. So that's what the medical record said in April 2010. And you can ask yourself if, based on that record, and you were a medical provider, whether you would have admitted Mr. DeMerilaire, to a psychiatric hospital involuntarily against his will in April of 2010. I can tell you that based on that note, I certainly would not have. And New York State, if I had done so, probably a court would have released him very quickly. Unfortunately, you may be familiar with the expression that hard cases make bad law, and that may have been what happened here. Because in a tragic case, in July of 2010, DeMerilaire broke into Shirley's home and shot her and her son to death. He also attempted to slash the throat of a second son, then he returned home and killed himself. And Shirley's mother brought suit on behalf of the estate. Dr. Ashby argued the attack was not foreseeable, and that Ashby did not owe DeMerilaire the victim's duty of care. Such a duty would have conflicted with statutes limiting disclosure of patient information, and no duty to warn or protect third parties can be imposed on psychiatrists absent an actual threat to an identifiable victim. And the court disagreed. The court said without question mental health professionals face an incredibly difficult task of ascertaining whether a patient will act violently. However, given society's strong interest in preventing violent attacks by mentally ill patients, as well as the recognition that the mental health profession has long accepted a duty of disclosure when a potential victim's safety is in jeopardy, this factor weighs in favor of imposing a duty. The key here is it's not a duty against someone who is specifically threatened, but against a duty to warn anybody or protect anybody who might logically be a potential victim of the patient, which is a much larger breach of confidentiality, and the American Psychiatric Association has been lobbying actively and working hard to keep this principle from expanding beyond the state of Washington. So the way to think about this is over the course of the last century, there's been an expansion of the duty to breach confidentiality, or an expansion of state authority to serve the public health in situations where a particular negative outcome is predictable. However, the rights of third parties are limited. One example I always like to offer is something that actually I discussed in an essay I wrote years ago called An Absence of Jello in the Southwest Review. And I was tested for Alzheimer's genetic risk, the APOE gene. And while the neurology is beyond the scope of this talk, what's important to know is that if you get tested for your risk of Alzheimer's disease, you also, to some degree, reveal the risk of your close relatives, particularly your parents, getting Alzheimer's disease. And so you may tell them even if they don't want to know, or even if you choose not to tell them, how you choose to live your life may reveal the secret to them. And this is true of a number of other diseases. So genetic testing has led to the danger of unmasking. Similarly, if you write a book with your patient's permission and they share with you information about third parties, that information is not protected. You can share that information all you want to with the public. So third parties have very limited rights vis-a-vis psychiatrists and physicians. I want to mention very briefly the subject of disclosure. This is sharing information with others or the state that otherwise would be protected by confidentiality rules. And there are three different standards. There's mandatory, when something must be disclosed, prohibited when it cannot be disclosed, and permissive when it's allowed to be, but the doctor has discretion. Almost all of these rules are determined by state law. There is no national rule governing different types of disclosure. And the penalties are generally civil, meaning you can be sued, you can lose your license, you can't go to prison. The two exceptions are failures to report child abuse, to disclose child abuse, and failures to keep confidential HIV status. I'm going to share the details of New York law in the next couple of slides, just to give you a feel for what the rules are, but they will differ between states. So in every state, child abuse must be reported. In New York State, there's a standard that says if you have a reasonable suspicion of child abuse or neglect. But in some states, it's a social duty, meaning if you discover the information in any setting, professional or social, and you're a mandatory reporter, you must report it. In New York State, it's just if you discover it in a professional setting. So you're at a party and you learn that somebody is abusing their child. Ethically, you may have an obligation to report this, but legally in New York State, you do not. Abuse of nursing home residents and other institutionalized individuals must be reported. Impaired physicians in New York must be reported. And as I mentioned earlier, this applies to social and professional situations. And then a number of public health hazards like gunshot wounds, knife wounds, communicable diseases, HIV status. In contrast, New York allows the doctor discretion on whether or not and when to report a number of different public hazards. So as I mentioned earlier, impaired driving is one. Use of parties who lack capacity is another, suicidal minors, um, protecting patients from severe injury or death. So there's a lot of latitude in what doctors can do here. There are many situations where you may want to encourage a patient to report themselves, like if somebody's impaired due to epileptic fits for driving, but that if they don't, you don't have a legal obligation to do so, though it may be in the patient's best interest and the public to do so, and you can if you wish to. As I mentioned earlier, disclosing in a permission system has consequences. So the patient themselves is often lost to follow-up, and you lose an opportunity for a therapeutic relationship. Um, Many times the patient isn't compliant with the state authority or intervention anyway. So if you report an impaired driver and the state takes their license away, they may continue driving. And third, there's collateral damage that others may lose faith in the system and not share information that may actually create a greater danger to the public. And then there are certain acts that are not reportable in New York, even if you want to. You don't have discretion, though they are in a number of other states. So intimate partner violence, spousal abuse, the patient can choose whether or not to report, but you can't without their permission. The state's view being, on the one hand, that victims are most suited to figure out whether or not it's in their best interest to report, and also that victims of abuse won't come forward for medical care if they fear that they're going to have their abusers reported. Elder abuse of elderly patients in an outpatient setting who have capacity to make their own decisions in New York are treated just like everybody else, no matter what their age. Animal abuse, confessions of past misconduct. So in the movies, the doctor may be able to report where the patient says they hid the body, but in New York State, you actually cannot do that. And then ongoing frauds, deceptions, property crimes not related to health or well-being, with the one exception of insurance fraud. The goal of this talk was not for you to memorize the specific details of when things need to be reported. When you are a provider in a particular jurisdiction, you will learn those rules. The goal is for you to think about the wide range of situations that are open to the possibility of reporting, what the sociological implications are of requiring, allowing, or not allowing reporting. And most importantly, thinking about how you balance the duties of doctors to individual patients, to third parties, and to the general public. Please do not hesitate to reach out to me individually with specific questions. Alternatively, I will find a way to leave an optional group session for us sometime during the course of the week.